Hello, everyone. Welcome to another Agenda IDS. I am Patrícia Porto, the Academic Coordinator of Dannemann Siemsen Institute. Agenda IDS is an online event in which we address important topics regarding intellectual property, law, and technology. I always invite experts on the subject to share their experience with us. And those who miss the live event will be able to access the record content available later on Dannemann Siemsen Institute website. And today, in celebration of the World IP Day, we will be discussing the topic second medical use patents, enforcement, and skin label. This is a hot topic in Brazil, and that will be discussed by two experts on the subject from the perspective of the United Kingdom and Brazil's regulations. And now, please let me introduce our guests. To talk about the issues under the UK regulation, we invite Ms. Amy Cullen. Welcome, Amy. This is a senior associate in Bristows IP Litigation Department in London, with a particular focus on patent litigations. Amy's practice includes patent disputes in pharmaceutical, telecoms, and consumer product sectors. And to discuss the matters as regulated in Brazil, we invite Bernardo Marinho Fontes Alexandre. Welcome, Bernardo. Bernardo is a partner at Dannemann Siemsen, advisor of the Dannemann Siemsen Institute, an attorney at law, and an engineer. His practice focuses on patents, access in patent strategic litigations, and administrative prosecution. I would like to thank you very much, our guests, for being here with us today. And now I will give the floor to Bernardo. Thank you very much. Bernardo, the floor is yours.
Thank you, Patricia. A sincere thank you to the Dannemann Siemsen Institute for inviting me to participate in this discussion on a truly fascinating area of the patent law, and especially with my colleague, Amy. I really appreciate the opportunity to talk about this specific issue. Today, Amy and I will embark, I guess I can say, on a small journey together. We'll talk about the strategies for navigate the complexities of second-use patents. However, before we start our conversation, I felt that I need some, let's say, background to make sure that we are all on the same page, right? Especially because we're having specific terms regarding second use, medical patents, skin label, and so on. But focusly in Brazil. So I will outline the key milestones and developments around second medical use patents and skin label here in Brazil. This will serve, I believe, I hope so, as a foundation for our discussion moving forward. So let me share my screen over here. Oh, it's not. I was true. Sorry, guys. Technical. Not technical. A panelist problem. I was in the middle of the presentation. Sorry. Everything is working, Patricia?
Yes, perfectly.
Okay. Yeah. So let's start with the beginning, right? Our journey, as I can say, starts in May 1996, when our current IP law was enacted. Why am I talking about this law specifically? Because with that law, Brazil now accepts patents for pharmaceutical inventions, right? Before that, pharmaceutical inventions were not a patentable subject matter in Brazil, but from May 1996, as a matter of fact, May 1996, because the law only became effective 1 year from its issuance, patents could be granted for pharmaceutical invention as long as, of course, they are patentable, meets the requirements of novelty, inventive step, and industrial application. Now, the other milestones regarding this topic is February 1999, because Brazil issued this law 9787. Why are this law is important? Because this law creates the rules for generic versions here in Brazil, right? And one important thing here that I need to say about this law is that this law does not authorize a skin label because of because of 2 points. Because this law established that a generic medicine must have the same therapeutic indication as its reference drug and must differ only in a few features of the generic of the reference drug regarding size, shape, expiration date, patent, and labeling and excipients, right? So generics, according to this law, must have the same therapeutic indication of its reference medicine. Now, another important development here in Brazil regarding now second use patent is the issue when the patent office issue its guidelines for pharmaceutical patent application. Why this is important? Because now with these guidelines, the patent office confirmed that second medical use is a patentable subject matter in Brazil. Okay. Now, because the patent office was already granted patent for that, but now it has become a rule, right? And providing the examiners the support and how to assess the patentability criteria for this type of invention. And one thing here in Brazil that even though this guideline is from 2002, until now, we do have second medical use in Brazil is patent in the Swiss style claim. For those who doesn't recall, a Swiss style claim is a specific type of patent claim using pharmaceutical to protect the use of a non-substance for a new medical use. In other words, this type of claim defines use of compound A for manufacturing a medicine, a pharmaceutical composition for treat a disease W that's different from the previous use for this non-compound, right? So we still have Swiss type format. Now, even though the patent office has issued that guidelines confirm the patentability of second medical use, there was doubt if the court would have the same understanding of the patent office, if the court would understand that second medical use is a patentable subject matter, because that's the important one thing, because our IP law does not state that pharmaceutical inventions are patentable, does not state second medical use is patentable. They only say, our law only says what is not patentable. And there is a discussion because, and also this IP law states that therapeutic methods are not patentable subject matter in Brazil. So that could have a discussion whether the court would understand a second medical use as some sort of a therapeutic use, therefore it would not be a patentable subject matter. But this doubt was surmounted in April 2013 when the Federal Court of Appeals of the Second Region in Rio de Janeiro issued a decision from the two IP specialized panels of this court. They got together and issued a ruling confirming that second medical use is a patentable subject matter in Brazil. Now we have a jump from, I don't remember, from 2013 to 2020. As a matter of fact, June 2020. Why am I saying that? Because in this month, this particular time, a generic company filed, I guess, a lawsuit before the federal courts of Rio de Janeiro, seeking an annotation in the patent. Basically, this annotation is something like that. In my humble opinion, the patent covers what the patent covers. They just want an annotation in the first page of the patent say that this patent can only be enforced against basically the use of the substance for the specific treatment, because just for let's so annotation in a second medical use patent. Okay, basically they want to avoid that the patentee could use this patent, the second use medical patent, against a generic without this therapeutic indication covered by the patent. Why is that? Because this same generic company has carved out the patent therapeutic indication from the label of its generic version, okay? And, oh, sorry, wrong button. And that's one thing that I mentioned. I'm not even talking about the federal law that, in my view, states that skinny label is not permitted. But the Anvisa's internal rules, Anvisa is the regulatory agency here in Brazil, Anvisa didn't have rules confirming the acceptance of skinny label. Even without that, some generic companies managed to carve out the patent therapeutic indication from the label of its medicine. Basically, they found, I guess I can say that, a loophole in the Anvisa systems to obtain that. They are using rules for Anvisa that do not apply to generic versions, and therefore they managed to carve out the patent therapeutic indication without Anvisa's approval. And now, that's why basically we are having this discussion here, because in last year, even though Brazil grants second medical patents since 2000 and something, the beginning of the 2000s, only last year we have a decision on the merits, the first case of a patentee enforcing a second medical use patent here in Brazil. And that's why then the discussion started. We are having a discussion on the courts. That's why, as Patricia mentioned, this is becoming a very hot topic in Brazil. So the patentee filed this complaint for infringement of its second medical use. The judge grants the preliminary injunction based on this patent, and within 4 months later, which is incredible fast for Brazilian standards, the judge rules the case. They issue a decision on the merits, confirming that the generic version infringes a second medical use patent despite skinny label. Because you guys remember, even though it was not allowed according to Anvisa's rules, this generic company managed to carve out the patent therapeutic indication. Okay, but even so, the judge ruled against the generic company. Basically, the judge have the following understanding: one, skinny label is illegal, as I said. So the judge confirmed my opinion. But they say that the federal law does not authorize skinny label, therefore, the the skinned label is not permitted in Brazil. Then there is infringement. Okay. But the judge go further. The judge even said that even if skinny label would be legal in Brazil, still there is infringement. First, because the generic company commercialized its generic version with the full label, so there was infringement at least from that moment. And the generic company confessed during the proceeding that with the skinny label, they could not avoid the use of its generic version for the patent therapeutic indication. And therefore, the judge, with that confession and with evidence that this generic company has commercialized its generic version for the patent therapeutic indication, ruled that there is infringement. And going to the end, just more two steps of this history background. February of this year, Anvisa finally started to accept skinny label. The Anvisa issued in December of last year new rules accepting skinny label, but this rule became effect only in February of this year. So now Anvisa starts to accept skinny label here in Brazil. Even though, I mean, I must stress that again, that the Anvisa's rules are against the law, okay? Because I'm not saying that Brazil should or should not have skinny label here in Brazil, but what I'm saying that, in my humble opinion, my understanding of the law, the way of implement skinny label in Brazil is not through Anvisa. It's not simply Anvisa issuing rules saying that skinny label is now accepted. We need to change the law that creates the generic sense, because this law clearly states that generic must have the therapeutic indications of its reference drug and can only differ in other aspects, not regarding therapeutic indications, excipients, size, and so on. Okay. And the last development here, you guys remember, I mentioned that decision on the merits from the trial judge. Of course, the generic company has filed an appeal on the merits against this decision, and we are still waiting the final ruling from the appellate court. The appellate court start to rule this appeal in April. Yes, April, this month. Yes, that's right, this month. And the case is, unfortunately, it's two judges voted in the sense that the trial judge decision must be canceled in order to make what we call perícia, right? In English would be a court-appointed expert analysis, because the generic company argued that the second medical use covered by the patent would be anticipated by the prior art. So the judge understood that, so if there is this discussion, we need a court-appointed expert to decide that. The third appellate judge asked more time to analyze the case before rendering her vote. So we are waiting the continuation of this judgment session. So that was basically the main milestones regarding second medical use and skin label here in Brazil. But now, Amy, let's start, right? Should I read? Okay.
Yeah, no, I was just going to say thanks so much, Bernardo, because it's really helpful to understand all that background and context, and how it's taking time to get this clarity about what the law is and how things stand in Brazil.
Great. So, Amy, I want to start with a question, right? Because of course, you probably know, of course, the US Supreme Court decision from November 2018, right? Because it was in a case between Warner Lambert and a generic companies regarding the use of generic pregabalin for pain treatment. The patent in question was ultimately held invalid, right? Rendering the infringement moot, meaning the Supreme Court did not need to address infringement in this particular case. Despite this, judges of the UK Supreme Court still provide the assessment of the approach to assessing infringement of Swiss 4 claims. That's why I'm talking here, because it was an infringement of Swiss 4 claims, and in Brazil we still have this type of claim. It's essential to note, at least let me know if I'm mistaken regarding the understand of this decision, Amy. The judicial comments on infringement are a Latin word here, obter dicta, right? Meaning that they hold no bind power on the lower courts, right? It's basically understanding from the judge, rights, and so on. Moreover, the judge expressed different opinions, raising concern about the potential impact of the UK Supreme Court's guidance, right? Because as the comments regarding infringement was obter dicta, I guess I can say that they are guidance on how to assess infringement of Swiss form claims. And as I said, in Brazil, we still have Swiss 4 claims, and this guidance might be relevant to Brazil because we have Swiss type 4 claims, right? Amy, move on to our first inquiry. And it's not actually a question, but a welcome request, if I may. Could you please talk a little bit, discuss the different opinions expressed by the judges of the UK Supreme Court regarding the assessment of infringement of Swiss form claims, please?
Yeah, absolutely. Yeah, so you're absolutely right to say that, these comments were obiter dicta, so they're persuasive for the lower courts, but they're not strictly speaking binding. And also, as you say, in the UK, perhaps it's more likely we will be looking at the new form of claim, EPC 2000. So it's not exactly clear also how these comments on the Swiss form claims, what impact they might have for the new form of claim. But and you're right to say that the judges had different views, but only in respect of direct infringement. So the Supreme Court was asked to consider infringement on two different bases, indirect infringement and direct infringement. So the direct infringement here was dealing with the product of the process, using the compound in the manufacture for the purpose, while the indirect allegation of infringement was supplying this essential means in order to put the invention into effect. And there's a question about how that should be interpreted. So I guess, first of all, maybe I can ask a question back, because in the UK, the one thing the judges did agree on was that there was no indirect infringement. So they did reject the allegation of indirect infringement, and they were all decided on that. Whereas I think maybe that's perhaps out of step with other countries in Europe, where it looks like the courts might consider an allegation of indirect infringement. So do you think in Brazil, this is going to end up being particularly one or the other? Do you think that people will be arguing it in both ways, indirect and direct infringement?
You're talking about direct infringement from the generic company, right?
Well, so I guess in the case of the direct infringement, it would implicate anybody who deals with the product of the process. So if the process is infringing and then the product of the process, that could implicate people who deal with the product downstream in a commercial sense, so wholesalers or distributors. And if it's indirect infringement, then we're looking for a direct infringement that could, whether that could be a pharmacist dispensing the product with the label on it to say it's to be used for a particular indication, then supplying the drug to be used in that way could be seen as being an indirect infringement. So yeah, I think it's kind of it's all very much open to argument, and I don't know where things have got to in Brazil. Is it being argued in both ways?
Okay, I mean, in that specific case that I talk about it, the only direct infringement, there is no indirect infringement, right? And I struggle, even though first let's start. In Brazil, Swiss type use claim, right? So we are talking in a use claim is a process claim.
Yeah.
So according to our law, a process claim also covers the product directly obtained by this process.
Yeah.
Okay, that's for so in theory, I mean, at least the pharmacy, the doctor could be infringing this second medical use if they are prescribing for this. But I really struggle to see indirectly or directly infringe this second use medical patent, especially because in Brazil, our law established that therapeutic method is not patentable. And basically, when the doctor is prescribing, they are doing a therapeutic method here. They are prescribing the medicine, right? So talking about indirect infringement from a generic company, I don't see, because if there is no direct infringement from the pharmacy on the doctor, cannot exist an indirect infringement from the generics. But I do believe, and that's what we are discussing here in Brazil. I don't know if this case or other case will reach the higher courts, but so far, only direct infringement. Basically, I'm now copying the judge's rationale in the decision. As long as the generic manufactures a medicine that can be used for the patent therapeutic indication covered by the second medical use, then there is infringe. Direct infringe.
Yeah, I mean, I think that that's something that was really on the minds of the judges in the UK as well, is that this problem of creating infringement for the parties kind of downstream of the manufacturer, so the pharmacists or the doctors, when obviously there is this exclusion for methods of medical treatment. And I think that was, an important policy concern. But I think for indirect infringement, the UK judges of the Supreme Court just felt that since the process covered the manufacture, then that infringement couldn't be completed by the downstream parties because they weren't carrying out any act of manufacture. And that's why the kind of court just ruled out the indirect infringement. But speaking about the direct infringement, and that's where you're absolutely right, the judges did take different views in relation to the direct infringement. And they were being asked to consider the kind of mental element. So at the hearing, the parties, both the generic companies and the patentee, were agreed that there needed to be some kind of mental element, some kind of perhaps intentional. It was argued about what word was being used. And then the generic company took the view that that kind of intention needed to be a subjective intention. So the patentee needed to be able to prove that the generic company had a specific intention that the product should be used in this way. Whereas the patentee took the view more aligned with what you've described, Bernardo, that even if it's only foreseeable that the product could be used in this way, then a reasonable company should be taken to intend the consequences of its actions if you can see that those consequences are going to follow. So in that case, just it being foreseeable would be enough for the product to be for the purpose, for the patented indication. And that was during the hearing. And then the judges were not obviously not sure about only those two options, and they asked the parties to address them further about a third option, which is kind of referred to as the outward packaging analysis or approach, and it's often kind of considered to be aligned with the German law style approach, which is really looking at the product and then focusing more on the characteristics of the product, which basically in the case of a pharmaceutical is very, the label is a very important part of that, because, you know, the product itself, it is identical. And so after the judges had been asked to be addressed about that question after the hearing, in fact, two of them took the view that that would be the way to assess infringement. So look at the product itself and assess whether, based on its outward characteristics, particularly the label, it's been prepared for the patented indication. So that was Lord Sumption and Lord Reed. Meanwhile, Lord Briggs and Lord Hodge did think that there should be subjective intention on the behalf of the generic company. So you actually have to prove that they'd intended, you know, whether you could find that through disclosure or through other means, you know, for example, the fact that they had projected in their internal planning that they were going to sell some certain amount, but, you know, that was not a straightforward thing to prove. And the judges were worried about that, you know, how can you produce that evidence? And then the fifth judge took a view that it wasn't clear whether it was completely aligned with the other two groups, and probably more aligned with the outward packaging approach, and saying really the question is whether the generic company has made it clear that the use of the product should be limited. And that judge sort of talked about, could there be some kind of labeling on the product that says this product should not be used for the patented indication? And, you know, there's a question about from country to country whether that kind of thing is permissible. So really, I think it's easier to say what the judges agreed about in terms of what they rejected. So they rejected that kind of foreseeable standard that the Court of Appeal had settled on, and that you've also, sounds like that's also where the Brazilian courts are heading. But the Supreme Court didn't endorse that approach. And they were just, I think that was a concern about whether other parties dealing with the product would be able to know whether it was infringing or not, because how can those parties know what was intended or what was in the, you know, what knowledge the manufacturer had when the product, as far as they can see it, just looks like it has the skinny label. They don't know. So, I mean, in Brazil so far, are those the kind of arguments that have been put forward? It sounds like the foreseeable test is something that the judges have grappled with.
Well, I mean, in this specific case in Brazil, the judge has not come up with a method and so on, because it was more straightforward, right? Because it was basically a confession saying that with the skinny label, I cannot prevent someone from using my product for the patent indication, and they have sold to the government, to the Brazilian government, their medicine for that specific treatment. So it was very straightforward analysis. There was not a discussion regarding intent, aspects of the mind, and so on. That's why it was more straightforward. I don't know. So in an eventual appeal, so far it's not the judgment is not about on the merits of the infringement. It's whether they should because in Brazil we have the dual systems like in Germany, right? Invalidity of the patent before the federal court and infringement before the state court. And there is a big debatable if the state court should or should not address patentability criteria and validity of a patent, right? And therefore, so far, the ruling of this appeal is going in that direction. If the state court can or cannot see if the patent is valid before analyzing if there is infringement. Right. So far, it's 2 votes saying that yes, we can, and let's see what they come.
I see.
And that's what there is a question here from Maria Isabel, and we mentioned sometimes when there is a question in the chat, we are about to answer, and then Maria Isabel realized that you just answer her question. And Maria Isabel, we're gonna I'm gonna ask Amy about something, and I'm gonna also answer somehow your question about the intent, right? That's why I'm shifting a little bit the gears here in order to discuss the concept of skinny label in the context of infringement of second use medical patents, because I can get this breakdown of the Supreme Court's deliberation that Amy just presented to us. Because as I guess you all know, skinny label happens when a generic manufacturer carve out an indication that's covered by a patent in Brazil, right? Basically, what they understand of this skinny label is that by not mentioning the patent use, the generic drug manufacturer or its distributor argues that there would be no infringement of a patent for a second medical use, okay? According to their opinion, they would not actively promote or encourage doctors to prescribe the drug for that patent purpose. But that would be a great skinny label, second medical use, but you know that life is not black and white. Sometimes we have some 50 shades of gray and so on. And that's why we have this amazing discussion, right? Especially because this understanding from the generics, they overlooks a crucial aspect, at least in my view, the off-label use, right? Because the doctors can, at least in Brazil, the private docs can prescribe a medicine for a use that's not indicated in the label, right? And especially in Brazil, we have a further particularity that increase the relevance of the second medical use and skinny label and the whole discussion that we have. Because the main buyer of a medicine in Brazil is usually the government, the MOH, Brazilian Ministry of Health, or the Secretary of Health from the states and city halls, right? And sometimes they starts a bid. I want to purchase the X amount of this drug here, and it does not indicate for the purpose of this purchase. I don't know, 60% is for use A, 30% for use B, and 10% for use C, something like that. They usually I want this X amount for this drug. And then it comes the discussion with the skinny label, the generic can participate in this build fully. If yes, then there is infringement of the patent, the second use medical patent. After all, even though they have carved out the patent indication, they provide to the government a medicine that will be used for the patent indication, right? So, in my view, that's, and I believe that the judge agreed with me in that sense. It's not, skinny label is not enough, right? We need to have something more to avoid infringement of a second medical use patent, right? In my view, the manufacturer or distributor has a responsibility to effectively deter the drug off label use for the patent use, right? They need to do more than that. And in that case, the generic company even said that with the skinny label, I cannot prevent my product to be used for the patent drug. So they have to do more. And what more, talking about Maria Isabel, I don't know. I guess it will be a case-by-case analysis. They have to do like an unequivocal communication to the public, to the doctors, to the manufacturers, distributors, the government, saying that you cannot use my product for this specific use because there is a patent and I cannot commercialize it for that sense, right? Otherwise, it will be, I mean, simple for that. They carve out, they don't take any actions and let the public decide, say, oh, I don't infringe because I have skinny label. So, and how about you, Amy? Do you agree with me? Is a skinny label a foolproof method to rule out infringement of second medical use, or there are limitations for this practice?
Yeah, well, I think absolutely that's it, Bernardo, isn't it? That's kind of the crux of the question is, are those two questions the same thing? You know, is it enough to have a skinny label to rule out infringement? And is it enough to have a skinny label to rule out use for the patented indication? Because, you know, if you can't rule out use for the patented indication, does that automatically mean that you must therefore be infringing? And where should that burden, that responsibility perhaps lie. I mean, and I think you can see that the generic companies, you know, they do stand to benefit financially from all the sales, regardless of the indication. And so it's both a combination of the system, the way the system works, which you have to look at in each country, and the kind of scenario you described, and also look at the party that's doing the commercial acts and benefits commercially, even if the use is for the patented indication. But I think a very similar situation to what you're describing kind of arose in one of the cases in the Netherlands that the Court of Appeal talked about, which was a similar case where the generic company had a skinny label, participated in a tender that would supply the entirety of all indications, and then wrote a letter after winning the tender to say, as a formality, oh, by the way, our label is only for one of the indications. And the court in the Netherlands said, no, that is infringement, because just writing a letter after you've already been awarded the tender, sort of as a formality, is not doing enough. So how much do you have to do? And I think you really have to look at the specifics of each system and how it works, because, you know, in the UK, where prescriptions are written using the INN, you know, it's not possible to know what the indication was. So when the pharmacist then receives the prescription, they've got no way of knowing whether they should dispense the branded originator drug because it's for the patented indication, or whether they should supply, it's fine to supply the generic product. And so, you know, basically, if the system doesn't allow that differentiation, or the tenders don't differentiate between what the indications are, then it's basically going to be almost inevitable that this kind of off-label use will occur. And then the question is, if it's inevitable, does that mean it's kind of too difficult for the generics to do something, or does it, you know, it's kind of out of their hands, it's just built into the system, or does it mean they should still try and do something about it? And I think there are some other examples, you know, so one company in the UK case, because obviously there were multiple generics, one of them said what it would do is store the product in its warehouse and then only supply it to a pharmacist if the pharmacist provided a copy of the prescription that showed that the prescription had been written for the patented indication. And actually, I believe the patentee, so Pfizer, Warner Lambert, agreed to that process to say, okay, in that situation, I can see that your supply would not infringe because you've seen some kind of evidence that this supply you're making is not going to be used for the patented indication. But of course, the other generic said, well, that's just not going to be practical. Yeah. How are we going to make any significant level of sales? Then it would make our product commercially less desirable. And also pharmacists might be discouraged, but there might be problems about sharing the prescription. It might make things too slow. So it's kind of, I think you can think of things that can be done that would definitely significantly reduce the probability of the cross-label use. Yeah. And I think you've got to be a bit practical in that circumstance. And patentees probably have to be a bit reasonable as well and say, you know, maybe we can't eliminate every single, but we can get it down to a de minimis amount if you take these certain steps, you know. And in the UK, there's quite a lot of scope for the parties to have that kind of correspondence and discuss these ideas. I don't know whether that's possible in Brazil as well, for, you know, maybe for the parties to ask the court to order certain practical steps to be taken, rather than just issuing an order that says, don't infringe the patent, but doesn't give anyone any actual practical advice about how to make sure they don't infringe the patent.
Yeah, I mean,
yeah.
Are you done or?
Yeah, sorry, please go ahead.
No, I will start asking you to provide me this Netherlands case number and so on, so that I can check. I was not aware of that. It would be good to read about it. And
I think that was Sun Pharma and Novartis, but that's from quite a while ago. That was from 2015. So, you know, before this was all kind of getting to be quite such a hot topic in Europe generally. But yeah, that's that one.
Okay, just for curiosity, for doing my homework here to understand other countries and so on. But I couldn't agree with you more, right? It's somebody also asked the reference, the case reference. So
Yeah, I might have to follow up with the actual reference. Well, because it's in Netherlands. I think it's a Netherlands case. I'm not so closely familiar, but
no problem. But with the party's
we can
name and
find
the
it.
data, perhaps if we Google it, we can
Mm,
find. But if you
mm,
please have it there in your hands, or maybe,
yeah.
I don't know, Patricia, can we
Yeah.
share something else with the audience afterwards? I guess, all right? Or no?
Well, I think it might be. Let me see. I might be able to find it from the Court of Appeal decision because they discussed it there. Let me see if they gave the reference.
Okay.
I
But
think
as you're searching, I couldn't agree with you more, Amy. For me, I answer also Maria Isabel. I don't know if I provide the complete answer to her question, but yes, uh, it's on a case-by-case analysis, right? They have to do something, I don't know, and also the patentee must be reasonable to try to see. They will not be able, to avoid all the off-label use or cross-label use of the generic version, but the generic version must have done something to avoid that. They have to do effective actions to avoid these use. So that when before the court they can say, Your Honor, I try everything. I do my homework, I try, but I cannot control every single doctor, every single tender in Brazil, but at least what I can do, at least to show good faith to the judge in a patent infringement case, saying that, well, there was this tender, as you said in the Netherlands case, before winning the tender, present that, well, I have the generic version. It cannot be used for specific use here because it's covered by a patent. I can provide you for the other use. Is that enough? I can give you a discount. I don't know, whatever. But then it will show good faith from the generic company and say, so that's great. But that's what I say. And before the court, yes, I guess it's possible. Even outside the courts, the parties, the patentee and the generic companies can have a discussion to settle some common grounds to see what would be acceptable and not, for which actions the generic company should done to avoid, so that I can feel that, yes, with that actions, me, the patentee, believe that you do not infringe my patent and so on. But in that specific case, there was no discussion about that. The only defense from the generic company was the patent is invalid and I have skinny label. So that's it. No further evidence, arguments, so on were presented. Therefore, I guess that's why the judge issued the decision so fast, because it was very clear. They said the skinny label is illegal, and if it's legal, it's not avoiding patent infringement. And regarding invalidity of the patent, I'm a state court judge, so I cannot rule on that. You need to go to the federal court, and as they did, right? So that's it.
Yeah, yeah. So I think the way the UK, I mean, if the UK Supreme Court's decision were binding in relation to infringement, actually, I think we're closer to a situation where a generic company might be able to say, I've carved out, I've done everything I need to do, look at the box. If it's not written on the label, then it's not intended for that purpose. Whereas, the Court of Appeal in the UK had taken a broader view, and I think other courts in Europe also take a broader view that there should be some more action than just carving out, because you have to look at the scenario in practice. And I mean, I think in terms of other ways of looking at whether the off-label use is going to occur, it's really just so important to understand very closely in detail, how does the product go from the manufacturer and get all the way through to the patient, because there might be steps, like really critical steps, where the off-label use kind of becomes inevitable. So if, for example, doctors, now prescribe by way of a drop-down menu, for example, from a piece of software where it gives them 3 choices of drug that they can dispense, and none of those allow the doctor to specify the indication, then it becomes difficult for anyone subsequently in the chain to know what the indication, what the purpose of the product was. If that piece of software is changed so that it could say, substance X for condition Y, or substance X for condition Z, then all of a sudden it's possible for those two things to be differentiated. So I think, as you say, to keep the goodwill of the court as well, it's helpful if the parties can show they're being constructive and not just coming with a problem that can't be solved, but maybe also looking for ways that it could be possible both for the generic company to make sales for the non-patented indication, which the patentee isn't trying to, maintain any kind of monopoly there, whilst also the patentee is getting a fair reward because they're managing to, make the sales in return for the research and investment that they've put in. So I think things like split tenders, things like looking at how the systems actually work and trying to work out if something can be done in advance to make that differentiation possible. In the UK, at least, I think that's the kind of thing that brings the goodwill of the court for the parties, and sees that they're not trying to overreach and not trying to insert their patent in a way that's kind of illegitimate, which I don't think that's what the holders of second medical use patents are trying to achieve.
Yes, thank you. And just to let you know, you basically stole my last question that I'm going to ask.
No.
I would ask what the patentees can do to make sure to avoid off-use label, to guarantee their rights besides going to the court and so on. But you already answered my question, no problem. But I'll give you the view of Brazil. I mean, I mean, you raise a very good point. I mean, split the tender. Wow, I never thought about that. Perhaps the patentee could even request the public government, the public institution to, well, I have a patent for this specific use. So issue a tender just for the specific use and let's the other tender keep for the other use and so on. That's a very good idea, because I was thinking about the first one is basically challenge the skinny labels right before the court, because as I mentioned before, skinny label, even though Anvisa has approved, but Anvisa as a public institute cannot do anything further than the law established. So if the law established that the generic must have the same therapeutic indications, Anvisa cannot issue a rule saying that generic can have less indication than the reference drug. So the patentee can also challenge the label of a skinny label before the court. Also, I mean, I don't know if it will help, but what I'm thinking here is sitting down with Anvisa to try to come up with a solution that would be better than fight before the courts on and on and on and on to about that, what we can do. Okay, skinny label, second medical use, but what we can do so that this specific patent, provides the coverage that the patentees deserve for developing this invention without compromise the other use that's on public domain. So what we can do, because when Anvisa issued this request for information, advice, and comments before issuing the new rules for skinny label, Anvisa created what we call consulta pública. It's a public consultation asking the parties to present comments on these possible new rules. And based on the rationale from them, this was not caring about the patentee, was basically say that second medical use patents cannot prevent the other use, a generic version to be used for other unpatented use. So, but Anvisa was not concerned about these off-use labels and so on. So perhaps we can have a further conversation on these and try to establish some ground rules for that. Just like as you mentioned, I don't know, put on the label, you cannot use for that specific use, or I don't know, put notes in the website. And I mean, that's what I think that we can do here in Brazil besides going to the courts and so on.
Yeah, absolutely. I think, acknowledging that there is a difficulty and trying to, engage with the stakeholders is a way of trying to move forwards. I think, another thing, I don't know whether this would be an option in Brazil as well, is that the court actually issued the National Health Service to provide guidance to doctors to tell them that they should prescribe using the brand name, which is not the usual practice in the UK. And the National Health Service kind of cooperated in doing that. So I think also thinking about the remedies or the things that the court can order, maybe not only just, just the traditional injunctions, but thinking about, the communications, ordering the generic, as you said, to make the kind of communications you talked about to the customers, or wanting to see evidence of how they're planning to supply the product. So I definitely agree with you that I think engaging with the other parties at the same time as pursuing legal options that are on the table, to protect these legitimate rights is it's good to pursue both of those in parallel.
Yes. And Patricia, do you see any questions? I guess no. There were some comments on the chat.
I think
I tried to put the case. I think, first of all, when I posted it, it wasn't to everybody, but I've just put down, there's actually quite a lot of discussion in the Court of Appeal judgment that I've put the reference to in the chat about the different case law from different countries in Europe, France, Denmark, Germany, and how they interpret Swiss form claims, and what kind of case law there has been about what constitutes infringement in a skinny label context. So I think that's a really good place that will be publicly available online. I think that's a useful resource.
Let me copy.
Hopefully you can find that by Googling.
And I'm just seeing here, there is just one oh, there is a new message here. Oh, just a comment from my partner, Luis Paulino. Yeah. He's mentioned that the current rules from Anvisa try to solve one problem, but end up creating another one. That's it, right? The problem, in my view, it was that Anvisa only focused on generics point of view. They didn't pay attention to the patentee's point of view to come up with a solution that would help everybody, right? Not just skinny label. Okay, you can have skinny label, but you also have to do something else. They didn't.
Bernardo, I think before Marisabel asked, there is a question. The first one was, I don't know if you see.
Delia Hansen, can you comment on any recent trends for Brazil in trying to obtain medical use claims for dosage regime aspect by litigation against ENP, Brazilian Patent Office? Yes, I mean, yeah. So it's not about skinny label, but we can talk about because it's second medical use patent here. Amy, you probably know, but according to these guidelines from the Brazilian Patent Office, you cannot patent what I guess I can say third and fourth medical use, right? Based on when the invention of the second medical use relies on the dosage regime or the patient groups and so on, according to the patent office, this type of patent is not patentable. I mean, if you are having a second use patent that the invention relies on the dosage regime, the patent office understands that if you need to rely on that, then you are talking about the therapeutic method. Therefore, you cannot patent this type of use, okay? And there is ongoing discussions before the courts about that. And sometimes it's just a matter of trying to come up with the better language for the I don't know if there is somebody from the patent office here, because I don't know, they would try, oh, that you're trying to deceive me, but sometimes a matter of find a better language for the claim, let's say, to disguise this dosage regime in order to obtain the patent. But yes, there are ongoing cases. I don't know how many, but I would say some. They are trying to overrule this decision. The patent office basically rejects applications that were claiming second medical use, relying the novelty and inventive step based on dosage regime. So there are ongoing cases before the court try to overrule this decision from the patent office. So far, no decision on the merit test, at least from the case that I know. That I know. Any further?
I don't think so.
Any further comments, Amy? Any questions, doubts about Brazil, please?
I mean, I've got so many more things that I think we could talk about, but I think at the same time we probably can't cover absolutely everything. But no, I mean, I've learned a lot from the discussion, and I think it's very interesting to compare the approaches of different courts, because everybody's trying to find an answer to this question, and maybe at different times in different parts of the world.
Patricia, perhaps we should just like the Fast and Furious franchise, create number 1, 2, 3, 4,
Yeah.
like the top.
Yeah.
Yeah, if the audience like
1
the
hour
idea, we
pass
can
like very fast. It was so.
very fast.
Mm.
Perhaps we should
But
schedule another one for the
we
topics and
will.
so.
And we hope Amy accept again our our invitation to discuss further.
Oh, well, I would be delighted. No, I'm definitely, it's very interesting to hear about things, especially when things are moving on in Brazil and, you know, things are developing.
Amy, thank you so much. Thank you very, very much for attending this, for accept our invitation. It was very, very great. I learned a lot from the UK and the European system.
Thanks so much. Thanks, Patricia, and thanks, Bernardo.
Thank you so much, Amy, and thank you so much, Bernardo, for all the knowledge that you share with us today. I also would like to thank our audience for the questions and participations, all the information that we discuss here, even if the decision, the Netherlands decisions will be made available in our video later in the Dannemann Institute website. And we please suggest that the audience follow us and the Dannemann Siemsen Institute social media and website for the latest news, because we have a lot of good things coming. For example, in May, we have another agenda IDS. This time is on proof of trademark use, changing from patent to trademark. And we are also always post new articles and information in our website and social media. So we invite everybody to follow us. And thank you, everybody, and see you soon.
Thank
I think
you.
we can wrap up. Bye-bye.